SwayamPrabha. Digital India. Educated India.
Greetings to all of you. Once again, I welcome you all, dear students. I am Dr. Raju Machi, Assistant Professor, Faculty of Law, Banaras Hindu University. Dear students, as in the previous lecture, the lecture number 4, where we have discussed the rights of a banker. Now, it's a time that you know that the rights and duties are the coin of two sides of a coin. So, when we have discussed the rights of a banker, it is very important that we will have to see that what are the duties of a banker towards its customers. The customers is a very significant part of any banking system. So, not only to exercise the rights by the banker towards its customers, it is very, you can say, pious duty of a banker to discharge his duties also. So, we will discuss in the lecture 5 the duties of a banker towards its customers. So, dear students, I would like to recall the few things as I have already discussed with you in the previous lecture. The rights, when we are talking about, as far as concerned, the rights is very important as a banker, that he must have some sort of the rights. But at the same time, when I have discussed the rights, and again and again I reiterate one thing. What is that? That is the duty of a banker. And the duty of a banker, I have already mentioned that section 31 of the Negotiable Instruments Act. Negotiable Instruments Act is said that it is the duty of a banker to discharge his duties. What is that? As a banker, he has to honor the order which has been made by its customer. So, here we will discuss the duties of a banker towards its customers in the two heads. The one that is honor to check, and the second one is that because it is the contractual relationship between the banker and customers, and being a fiduciary relationship, because it's you can say the very important part of this, the second part of the duty which has been imposed to the bankers or the banking company, that not to disclose any information, not to disclose the information of third party. But at the same time, there are certain circumstances where the bankers is to disclose that information. So, we will discuss in the two areas. One, to honor the check, and the second, the duty which is very important as far as concerned, that not to share any information to the third party, but at the same time the bankers has to disclose the information in which is compelled or bound by the certain laws. We will discuss in the two. Let me allow to the first one. As I have told you that the banker's customer relationship begins with the opening an account. Unless and until the bankers is opening an account, there is no any kind of the relationship, because the opening an account is one of the first, you can say, the instance between the bankers and customers when they are entering into a contractual relationship. As soon as they enter into the contractual relationship, the rights and obligations naturally arises, and we have discussed the rights which is available to the bankers. Now, the first, as I have told you that I will discuss these obligations of the duties of a banker in the two heads. The first, one of the very important the duties which lies towards the banker, that is to honor the check. And the second one, as I have told you, that the duties towards its customers to maintain secrecy and the disclosure of information required by law. Now, the general obligations, as if we will see that to honor the check. Check is one of the very prominent, you can say, the negotiable instruments at the present time, where if you will see in the present time that when you are opening an account, then you will find that it is given or provided by the bankers as a package. Earlier it was not happened, it was not the practice. When you were requesting for the check facilities, at the time the bankers is providing the check, otherwise that the transactions can be made through the pay and slip. But now the bankers is, you can say that giving almost all its customers to the check facility, and that might be the reason that the check plays a very significant role as far as concerned to making all kind of, you can say, transactions when you are transacting with the bankers. As we know that the bankers accept the deposits from the customers with an obligations to repay to him by way of honoring the checks drawn upon the bankers. The banker is under a statutory obligation to honor his customer's check because it is recognized in section 31 of the Negotiable Instruments Act 1881, which reads as earlier I have also mentioned that the obligations of a banker, these obligations creates with a particular section, that is section 31 of the Negotiable Instruments Act 1881, which imposes the most, you can say, the significant duties towards the banker. And the bankers what says, the drawer of a check having sufficient funds of the drawer in his hands properly applicable to the payment of such check must pay the check when duly required so to do, and in defaults of such payment must compensate the drawer for any loss or damage caused by such default. Now let me tell you that when we are talking of the sufficient fund generally we understand that the equal amounts, the credit amounts must be available in the customer's account. That is not the sufficient balance as far as concerned that the banker practice. The sufficient balance is when the bank is looking towards to determine that the sufficient balance, the bank is determining the two way. The one that he will see that what the amounts, the credit amounts is available in the customer's account. That is the first, it's all right. That generally what we understand that what do you mean by the sufficient fund means, the sufficient fund means the customers must have that amounts in his account in the credit form. And the second thing is that if there is any kind of, you can say, the agreement is made between the banker and customers, particularly if you will see that when an account is opened by a customers in form of the current account. Normally the current account is used by the business people, it is not used by the general customers. So business people when they are opening an account with the form of, you can say, the current account, their purpose is to take some sort of the overdrawn facilities from the banker. And the banker normally it given an opportunity or provide an opportunity to its customers when he is accepting to open an you can say the open a current account. The current account is when we are comparing with the savings account. In the savings account normally there is a you can say the interest facility is available to its customers. The customers is entitled to get the nominal rate of interest over their credit amount which is available in the account. But on the other hand, when we are talking about this current account, there is no any kind of, you can say, the interest is granted by the banker to its customers. That's maybe the reason that the customers, why even they are preferring, as I have told you, particularly the business class of people, because at any time they might be need some of the extra money and how it can be met out. So the bankers help to meet out that needs, and when they are open and open a current account, that the current account is opened with a certain sort of the agreements that it allows its customers for the overdrawn facilities. So it depends on the. Now in the present time, if you will see that the such kind of overdrawn facilities is granted to the other customers also in terms of the you can say the credit card. At the present time, if you will see, every time you will find in your mobile that there's some sort of the message you might have received from the banking sector that you can have you can say the credit account, and the credit account is different from the current account, or the credit card is different from the because in the credit card there is only that the facility which will be granted, it will not allow you for the overdrawn more than that. It only facilitate you to buy or to purchase certain things, and it will make you for that payment. But as far as concerned that when we are talking about the current account, it enables you, or it enables the customers to overdrawn and for a certain limited period. There is no any kind of the interest is to be paid by the customers unless or until that period is exceeded. But the another very important thing is that even if there is no any kind of contractual relationship at the time of opening an account, but at any moment, suppose by mistake the the bankers provide that facilities by maybe the reason behind it, the banker act negligently and he accept the overdone facilities in such accounts at the time of opening an account which where the parties were not entered into that contract, but that was granted. So, when such kind of you can say the facilities has been extended to its customers, banker cannot withdraw that you can say that the facilities unless and until he is issuing a proper notice to its customers that you are not entitled to get such kind of the facilities, privileges, because there is no such kind of the contract. But the bankers has to be very cautious that when he is withdrawing that, otherwise the bankers has to compensate it. So, I would like to mention one case laws, that is the Fleming versus Bank of New Zealand. In this case, it was very clearly held that if the bank act negligently, the bankers is liable to pay the damages to its customers. It says, it was held that the duty of a banker to pay checks of its customers who keeps a current accounts arises out of the two implied stipulations between the parties. The first is that the bank will repay what he borrows from his customers provided that the latter makes a proper written demand for repayment at the current bank branch. The other is that a banker will not injure his customer's credit by refusing to pay his checks except on a reasonable and proper grounds. If we will see that the second part of the first part is I have already discussed with you the decisions which we are if appears from the Fleming versus the Bank of New Zealand. The first part you will see that this is the duty towards the banker that he has to repay whatever may be the amount, as it is already mentioned under section 31 of the Negotiable Instruments Act also, where the banker's liability is to honor as much as it is the credit amount is available. And as far as concerned that when I am talking about the sufficient fund, then I have discussed the sufficient fund not only determined on the available of the credit amount, but it will be you can say that the determined on the basis of the arrangement between the banker and customers. That is very important. When any kind of the arrangement which has been provided to the bankers has to discharge that. That is very important. If the bank negligently, if denied to pay or dishonor any of the check, and if any loss occurred, the customers has a right to claim damages towards the bankers, and the bankers is liable to pay it. So, that the same things observations have been made by the Fleming versus the Bank of New Zealand. The second part of the decisions which I am taking here as a reference, it said that on the other ends that the banker will not injure customers' credit by refusing to pay his checks except on a reasonable and proper grounds. When we are talking the reasonable and proper grounds, I will discuss the some of the reasonable and proper grounds. Again, that which the another kind of you can say the liability which lies towards the bankers, but the bankers has to ensure that the money which he is going to pay, because the honoring means he is making the payment. When he is making the payment, it is very important that the payment is going to be made to the right persons. So, in that purpose, he has to ensure. How he will ensure? There are the certain conditions or the circumstances which I like to share with you. When he is honoring the bank is honoring the check, then the banker is bound to honor his customer's check provided the following conditions are fulfilled. That means, under section 31, it is all right that the duty imposed towards the bankers that he has to honor, but the bankers cannot be compelled to honor the or you discharge the rights or duties which is imposed under section 31 unless and until the bankers will satisfy the following conditions. These conditions are, there are 14 conditions which are given there. I will discuss one by one. The first one is the sufficient balance. The second one is the presentation of checks within working hours of business. The third one is presentation of checks within a reasonable time. The fourth one is check should be present at the branch where the account is kept. Fifth one is signature of the customer. The sixth one is proper form of the check. The seventh one is mutilated checks. Eighth one is correctness of the amounts in words and figures. The ninth one is material alteration. The 10th one is proper application of the funds. The 11th one is reasonable time for the collection. And 12th one is existence of a legal bar. And the 13th is death, insolvency, etc. of a customers. And finally, it is talking about the checks of partnership firm company accounts. We will see one by one. As I have told you that although, again I am repeating it, section 31 imposes duties towards the bankers to honor the check. Bank will dishonor if he will find in any of the, I am using the term, the technicalities. What are the technicalities? The technicalities are given in the following 14 conditions which I have already read out before you. So, I will coming to one by one by citing some of the examples. As I have told you, the sufficient funds. The sufficient funds, as I have mentioned, that the bank, whenever the bank will determine, he will determine by the two way. The one, as I have told you, that he will see what is the credit amount is available in the customer's account. That is the first one. The second one is, that is there is any kind of the arrangement between the banker and customers, which I have already discussed with you. Again, I am recalling these two things. That is, the sufficient balance is very important. Sufficient balance, when we are talking about that, as I am talking about the credit balance which is available. As far as concerned, that if you will see the general practice of the bankers, that you have to maintain some the minimum amounts with your bank. Now, the questions before us or before the banker, that whether that the minimum amount, the check which is issued, suppose a check is issued by a customer, the rupees 10,000, and the credit amount is available in your account only 10,000 rupees. Now, that the 10,000 and the credit amount is available in your account, that is 10,000, minimum balance which you have to record with your account, for example, that is the 2,000 rupees. So, now that the minimum amount which is maintained, the 2,000 rupees, but it is your money. If you are going to close your account, then the bankers will return all the money, except any kind of you can say that the service charges or accessible charge, whatever may be applicable to deduct from your account, the banker's liability is to return all the amounts. So, the bankers will take in that way, and the bankers will accept that the amount which is available in your bank, that is credit amount, if the 10,000 is there, he will not go for the minimum. Most of the practice which is adopted by the banking sector, as far as concerned, to determine that to honor the check, he will honor check, and if the minimum amount, if you have you are not maintaining, that the bank may charge some sort of, you can say, interest, but the bank will not deny for the payment of it. He will honor that, but the bank have the rights that I have already mentioned with you, the ancient charges that he may charge, and at the same time that maybe in the compound interest, he may charge the compound interest, but the banks will go up to that extent, the credit amount which is available in the account, and he will honor that. The second thing, as I have already mentioned, that if there is any kind of the arrangements, and that arrangements may be at the time of opening an account or the latter part, if the bank grant that, even by that without entering into any kind of the contract, if without any kind of the contract, if the bank facilitate that or the grant that kind of, you can say, the facilities to its customers, the bankers cannot withdraw unless and until he is providing a proper notice to the customers that sorry, we have accepted the mistakenly and you are not entitled. He has to provide the notice for it. That is very important. Now, the second very important thing is the bank will not honor your check if it is not presented in the proper business hour. There may be certain times we will find that there is under the negotiable instruments, the banking hour is decided, okay, whatever may be the working hour. The working hour may be for the public, that is 10 to 3, suppose 10 to 3. So, you will have to present your check within that period between 10 to 3 p.m. and the bank might be open even after the 3 p.m. So, that is not the business hour. The banking is open for their own affairs. The officers or the bankers, they are doing or they are completing for their pending works, but the bank is open, but that is not for the purpose of the general public. That is not for the purpose of you can say the banking business. So, you will have to present your check within that stipulated period. The third, it is talking about the presentation of check within a reasonable time. When we are talking about the reasonable time, that means in the present time, when we will see the check is valid for 3 months. Earlier it was the 6 months. When you will read the 138 of the negotiable instruments, section 138 of the negotiable instruments, then you will find still the 6 months period there, whichever is earlier, the term is there. That is why there is no any kind of the amendment has been made. So, the check validity period is from the date of issuing. The date of issuing, it is valid for the period of 3 months. So, the reasonable time is that within 3 months you will have to present before the banker, and there may be the date, that is the pre-date and that is the post-date. In case of the post-dated check, even that is we are treating that the stale check one, that means you are presenting after the expiry of the 6 months, or even in the pre-date, suppose a check is given to you by A to B and he has mentioned the check that is the letter on any date. So, unless and until the date is coming, you are not entitled to deposit, but that will not dishonor on the basis of that it is a stale one. The bank will not make pay. For example, in case of you can say that the cross check, the bank will not pay it, it will keep with it, or sometimes he will inform to its customers because earlier the customers has to pay or you can say present the check at the counter itself, but now there is the separate you can say the we have the deposit box is available with the every bank. So, you are putting that check and you are getting the printout of that. So, the bankers only know when he is collecting all these checks from the box. So, he may inform you and he may not inform you, that he will wait, okay, that when the time will come he will you can say that credit the amounts in your bank account. So, it is the discretion of the bankers may inform you, the bankers, but you will have to present within that the you can say the stipulated time, that is reasonable time. Check should be present at the branch where the account is kept. It was the earlier that what happened, that the check which is issued to a particular bank, you will have to deposit in that bank only. But now due to the changing scenario, the check that is the check has the different kind of you can say the multi-city check the bankers is providing. So, it is not necessary that you will have to present in that you can say the branch only, you can present in the other branch, and if the such kind of check is there then it can be you can say the payment can be made in the other branch also, but earlier it was not there. You will have to present the check in your own branch where the check is issued. You will have to, if you wish to get payment, then you will have to present in that branch only, then only the payment is made, and the other branches is not liable to not liable to pay or not liable to honor. But at the present time, if it is a multi-city check, then it can be paid by the other branches of the concerned bank. Now, as earlier I have also discussed, that is the signature of the customers, that is very important. So, that is I have told you that to ensure that the check is issued by the actual you can say the drawer, the persons who is making the instrument, that is the who can be in case of the check the customers of a banker, only he can issue the check, because that the check is issued by the banker to its customers only. The customers having their check and the customers wish to discharge his liability to other persons, then it will be given to whom? It will be given to that persons, and that persons is when he is presenting before the banker will ensure that the validity of check through ascertaining, or you can say through the verify or through authenticate the signature which has been made. As I have told you, at the time of opening an account, your specimen signature is taken by the bankers and the banks will certify your signature through that. So, the customer's signature is very important, and the bankers can have that you can say that the bankers can be get the privileges from that liability if the signature is forged one, and the forge can be checked very easily. The bankers is liable to act negligently and the banker has to compensate it. Only the that's you can say that the rights is available to when the bank act by taking all sorts of precautions, and it is not easy to identify whether it is a forged signature or it is the correct signature in a you can say the naked eye. Then only the bankers can get the privileges, otherwise the bankers can be held liable for acting negligently. So, the customer signatures, without verifying the customer signatures, bankers, and if we find that the signatures differ, the immediately banker's duty is to return the check by mentioning that the signature is mismatched. Now, the proper form of the check, when we are talking about, as we know, that only the bankers can have that he is providing the check to its customers. Now, for example, A and B, they are the customers of the same bank. So, if suppose A and B, they are good friend, the A having the check facilities, the B also having the check facilities, they are in the same branch. What happened that suppose the A doesn't have check leaf. So, what he will do? He will ask to the B that you give me, because I have the same branch, I have an account in your branch itself. So, you give me a leaf of check, I will return when I will get it. So, when he is presenting that, we can say it is not the proper form of check, although it is issued by the bankers. Why we can call it that it is not a proper form of check? Because it is not given to that customers. You will have to keep in your mind that when the check is issued, it is mentioned in your ledger book, the check number which you have in the check, and as soon as he is putting, then he will find that the particular check is not issued to the customer A, because you will find that it is from the different customers, although that check is provided by the same branch, but that is not provided to that customers. So, if you are using such kind of checks, that will come under the definition of the check is not in a proper form, and the bank has to dishonor that kind of check. The bank will not honor. The seventh thing is that is the mutilated checks, that sometimes we will find the checks might be that when issuing it, the check might not be properly turned out, and if you will find that the numbers and the other things which are not appearing according to the section 10, which is very important of the negotiable instruments, so the apparent tenor, that is very important, and we find that the check is not properly visible, or maybe some part of the turnout, and again it is, you can say, the pasted and it is presented before the bank. The banker has to dishonor it, bank shouldn't accept and shouldn't honor it. Now, the next one thing which is very important, that is the correctness of the amounts in the words and figures. As far as concerned the correctness of the words and figures when we are talking about, then we will have to see that there are the certain things which is very important as far as correctness of the check, that the correctness of the checks, it is mentioned, but as far as concerned that I am talking about that the provisions have been made. There are the two things, sometimes we will find that the act is talking certain things, but in the practice you will find the different things, and there is no choices available as far as concerned in the hand of or at the end of the customers, that they will have to accept, because the banks will defend himself that it is not presented in a proper form, it is not you can say that it is not written in the proper form. So, in the technical grounds, bank has the discretion that he may accept, he may not accept, but the safe side is that bank shouldn't accept it. But sometimes what the banks will do, the bank is find himself in the comfortable zone, and how that he knows the customers, and the customers is presenting himself. If he is presenting himself, then there is no doubt he will ask immediately that okay, fill up the remaining part which is unfilled or which is not made. But again I am telling you that at the time of the audit will raise that why there is a overwriting. So, the bankers has no choice, but sometime even the act says the bank can accept. The correctness of amount in words and figure, as you have seen that there are three things you will have to, or the four things you will have to mention in the check. Remaining things are already available in the printed form. The one that it is going to whom, the payment will be made to whom, you will have to mention that, date is there, and nowadays the accounts number and the other your names, it is already printed, available in the printed form. Only you will have to mention the third things, that is amount. The amount you will have to mention in the words as well as in the figure. There is the practice, as I have told you, that under the Negotiable Instruments Act, under section 18, the certain things which he mentioned, but again I am telling you that the practice is entirely different from it. The banker's discretion lies, the bank may dishonor on the basis of it if he will find there is incorrectness. Now, what do we mean by the incorrectness when we are talking about that you have mentioned in the words the 1000 rupees, and in the figure because only you have to add one more 0. So, it becomes the 10,000. So, now there is a mismatch in the words and figure. When we are reading the section 18 of the Act, negotiable instruments is talking about that if it is written in the words, the amounts can be paid, but the general practice is if the banks will find, the banks immediately return that check by degenerating that there is a mismatch amount. But let me allow to read out the section 18 what says. The banker should verify the amount mentioned in the check. If finds the difference between the words and figure, then may refuse to honor it. That is the general practice. Again, I am telling you that the discretion, but sometime maybe it can be accepted by taking the plea on the basis of section 18 of the Act. Section 18 of the Negotiable Instruments Act 1881 lays down, if the amount undertaken or ordered to be paid is stated differently in figures and in words, the amount stated in words shall be the amount undertaken or ordered to be paid. If the customer writes the amount only in the words and does not write in figures, the banker should pay the amount. If the check is written with the figures only, then the banker should return it with the remark, amount required to be stated in words. Now, see, if we will read, then when we are reading this particular provisions which is given under section 18 of the Negotiable Instruments, let me explain the very important part. Again and again I am telling you that the bank should dishonor it. On the basis of that, the amount is mismatch. But in case when we will see that the certain things which is mentioned, what is the mention? That it is mentioned in words only, then section 18 is talking about the payment can be made. Or if the words and figures it is mentioned, and if the amount is mismatch, as I have cited that in the words you have written 1000, in the figures you have written 10,000, then you say the payment can be made the 1000 only. But as I have told you that the general practice which is the bank is applying in case of the correctness of amount in words and figures, normally the banker practice is that he is returning the check without making any kind of the payment by stating that amount required to be stated in the words, or if there is a mismatch of amount. That is the another. The material alteration, that is very important. As you know that most of the time when I am taking the classes of banking law, that I am asking to the students that it is your duty as a scholars of the banking law, what you will have to do, that you will have to create awareness among the customers. What? That you do not leave the margin on the left side when you are filling of the amounts. So, you do not give it the space, otherwise there may be chances of the alteration of the amounts. So, do not leave the space in the left side, whether you are filling the check even in the words or in the figure. If you are leaving the space, then suppose you have written the 10,000 and you are leaving the space in the left side, then someone may mention that the 1,10,000, and in the same thing happened that only he has to put only one only and it adds that 10,000 to 1,10,000. So, whenever you are feeling that you do not leave any space in the left side when you are filling the words or you are filling in the figure, you will have to be very cautious. So, the material alteration that is given under section 87 of the Negotiable Instruments Act, let me allow to read out the provisions what says. Section 87 of the Negotiable Instruments Act says, effect of material alteration. Any material alteration of negotiable instruments renders the same void against anyone who is a party thereto at the time of making such alteration and does not consent thereto, unless it was made in order to carry out the common intention of the original parties. Alteration by endorsee, and any such alteration, if made by an endorsee, discharges his endorser from all liability to him in respect of the consideration thereof. Then further the provisions, the two provisions which I would like to mention here, that is this, the section 10 which I have already mentioned, but the provisions of these sections are subject to those of the sections 20, 49, 86 and 125. Therefore, the banker should not accept a check materially altered. He should verify it and return the drawer. If certain material alterations are made by the drawer himself, may consider such a check, keeping in view of the same standing and status of the customer. If any alteration is made by the third party, then the banker should refuse the payment of it. That is very important. Let me explain. Nowhere it is written that how the check can be right or to fill of it. But because it is not written in any of the law that it must be right in the pen only, it cannot be right in the pencil. But at the safe side is that you will have to use the pen. Why? That easily it cannot be altered. So normally the bank, if we find any kind of the alteration, and the alterations might be that it was altered, or there may be even it might be at the drawer he has when he is filling that he find that some sort of the overwritten in the check. Immediately it is the duty of the bankers that the bankers shouldn't accept all kind of, you can say, the alterations, whether it is made by the maker itself, by the drawer itself, it does not matter. It is the duty of the bankers that any sorts of, you can say, the alteration which is made in the instruments, particularly in the check, it is the duty of the bankers that the bankers shouldn't accept or to honor. But sometimes what happens that if the customer himself is present in the bank, means the drawer is itself there, then again I am telling you that because now the alternate mode is available. I am talking about when the alternate mode is not available, because nowadays when you are become a customer of any bank, then you will find that not only the check, they are providing you a debit card which will enables you to withdraw the money from anywhere. So maybe there is no problem, but in the olden days where there is no, you can say, the electronic means were available to withdraw the money with the help of debit card or the credit card, or even you can say that nowadays even there is no need to carry the debit card or credit card. You can withdraw money with the facilities which is provided by the banker to its customer. So that was not the problem in nowadays, but in the olden days it was a problem. And if the customers, because he got only one leaf of check, and if the check facility is there, then you will not be allowed to withdraw money with the help of the pay and slip which is available for the other customers. So in that circumstances what you will do? So at that time it was accepted, it was corrected by the customers in presence of the persons who is allowing you to correct it, and it can be accepted in that way by putting your signature over that where you are making means or changing any kind of the changes has been made by the customers at the time. But now in any way the bankers is refusing to accept it, and the bankers will return it that there is a alteration. So it will not be accepted. The bankers have that right. The next one is the proper applications of the funds. Now the bankers will honor a check only when the funds are meant for its payments. For instance, if the trust funds are withdrawn by check for private use, the banker will not honor it. As I have told you that the nature of, you can say, the operations of account, that is very important. For the personal use, if will withdraw, that will not allow you, particularly in case of the trust fund. So the proper application of the fund is another. Reasonable time for collections. As I mentioned that when we will discuss about the collecting banker and the paying banker, we will discuss and the details. But here only I have to mention that the reasonable time for collections. Every bankers they are acting as a collecting banker, they are acting as a paying banker. As a collecting banker, it is the duty of the banker to collect the check which is deposited by its customers and that belongs to the other bank. So what he will do that he will collect that money, credit that amount in the customer's account, then he will make payment. So that what would be the reasonable time for that collections? if you'll see the customers cannot impose on the banker conditions that a letter should pay these checks blindly even when they are drawn against checks sent for the collections before they are collected. One case which I like to cite before you, that is Underwood versus the Barclays Bank. It was held that in the absence of an express or implied agreement giving the customers a right to draw check against uncleared items, the banker is entitled to return such checks with the remarks that effect not cleared. That again I am citing that these things were very important or the significant in the earlier days, but now as we know that the concept has changed. Now the check is not collected you can say by sending the check, only that the image is sent and there is a concept of the clearing house. The check is cleared through the clearing house, and if the bank wish to clear a check, it can be done within an hour, you can say within an hour it can be done. But still that the bankers will not pay unless and until your accounts will be amounts will be credited in your account. So earlier that the reasonable time which is given under the negotiable instruments, that is the fortnight, means the 15 days times were there if the branch is available in the remote areas. If not, then within 7 days you will have to clear it. But as I have told you, the concept has changed, and in the present time, as I have told you, if the bank wishes to clear your check, it can be cleared within a, you can say that within an hour. So there is no such kind of the problems nowadays. It depends on the banks, how the banks is acting, but there is no any kind of the reasonable time. The still that we are following the terms and conditions which is prescribed under the Negotiable Instruments Act, and it is very easiest for the banker. They will not go beyond that. Even if you deposit today, the tomorrow you will find that your check has been cleared, because due to the new concept of, and that the new concept is called, that is the clearing house concept. Then the existence of legal bar. The existence of legal bar is very important again, which I like to mention the one very important thing. Like this, the garnishee order. The garnishee order is given when the person is seeking out of the, you can say, the transactions which he made between the customers and the other creditor. So the other creditors who is may have the right to ask the bankers to make the payment through the banks, and he will go to get remedied before the bank, and the bankers may issue the garnishee order. And when the customer received, the bankers when will find that the garnishee order, he will stop payment unless and until he will clear the liabilities which is arises towards his customers in terms of the garnishee creditor. So the garnishee creditor, first it will be cleared by the bankers, and then it will be honored and the latter part. So if there is any kind of the legal bar, it says banker is relieved from his statutory duty of honoring his customer's check if there is any legal bar like garnishee order attaching the customer's account. The bank should not such instructions attachment by the courts, income tax officers immediately in the accounts, ledger and all concerned records, and avoid payment on checks to such customers. It is very important that if any kind of the instructions, whether from the any investigation agency, the bankers can have the right to seize, and the bankers will not honor if such kind of, you can say, the legal bar is coming from any of the existing authority. The 13th one is very important, as I have told you, the death, insolvency, etc. of customer. As soon as the bankers received reliable information about the customer's death, insolvency, etc., he should not it on the concerned records and should stop payment of checks presented before him after the intimations of the death, insolvency, etc. of the customers. As you know that the insolvency which you have declared, that the person is not in a position to pay, and if the bankers is discharging the such kind of things, the bankers can be held liable. And immediately that if he received from the authenticate sources that the person's died in the circumstances, again that the bankers has to immediately note in records and not to issue any kind of the checks which is presented after the death or insolvency of any customers. As I have already mentioned before you. Again, I would like to recall you that the checks or partnership firm, company accounts, that particular provisions is again, whenever a check from a partnership firm or a company is presented, the banker should verify whether the check is signed by the authorized persons or not. Similarly, the seals of the firm or company should be verified. Thus, a banker should take more precautions while honoring a check. If he neglects, it becomes very costlier in the shape of damages or losing money. So, again I would like to recall that these 14 the conditions which has been laid down, I am calling it that's the technical reason apart from that is section 31 of the negotiable instruments. Remaining are the technical things, but as a bankers, the bankers has to take all sorts of precautions when he is honoring the check. At any point of time, if the bank act negligently and if the bankers found that the bank acted negligently, the bank customers has a right to you can say the claim damages towards the bankers. I am coming to the second part, that is obligations to maintain secrecy and disclosure of information required by law. As I have told you that from the very first day when the bankers and customers entered into a relationship, and as a customers, when the bankers open an account for its customers, the relationship begins, and the liability towards its customers that not to disclose the information to the third party, because it is the goodwill of the customers. There might be the customers that due to because that the people have an impression towards his particular persons that he has an account, and normally that if the persons having an account in the bank, it is general assumptions that the customers having some sort of money with it. That is the general impressions or the general image of any persons, and the customers might have paid a check, for example, that he has given you can say the pre-date check or you can say the post-date check. In both the circumstances, we find with the instructions that the check will be deposited in a certain time, after certain time. So, before that he might have managed the amounts, but at the safe side, when the customer, the persons to whom that the pay receive a check, and he went to the bank and he inquired the bank that the A has an account in your branch. So, just you disclose me how much the credit amount is available in his account, and the bank disclosed that information. Immediately what happened, that the persons returned this check, and it said that no, we will not enter any kind of the contract for suppose any kind of the business purpose. They will deny it. So, the customers has a right to claim over the damages over the bankers. So, the bankers can be held liable in this. So, there is the things which is required, that it's a bankers, from the foundation of bankers and customer relationship is confidence and secrecy. The banker is under an obligation to take utmost care in keeping secrecy about the accounts of the customers. Keeping secrecy means that the account books of the bank will not be thrown open to the public or government officials, and the banker will take all necessary precautions to ensure that the state of affairs of a customer's account is not made known to others by any means. That means it is an obligation, it is a duty towards his customers that not to disclose any information to the third party. But there are the certain exemptions, we can say, which is available where the banker can disclose. These exemptions we will discuss, but before discussing that, again I would like to mention here one case laws from where that this the duty were imposes. The nature of the duty cast upon the bankers to maintain secrecy about the customers' affairs has been discussed in Tornier and National, Provincial and Union Bank of England Limited. While disposing the case, the banker LJ mentioned, let me allow to read out, at the present day, I think it may be asserted with confidence that the duty is a legal one arising out of the contract, and that the duty is not absolute but qualified. it is not possible to frame any exhaustive definitions of the duty. One principle, I think that the qualifications can be classified under 4 heads. What are the heads? Where disclosure is under compulsion by the law, where there is a duty to the public to disclose, where the interest of the bank require disclosure, and the fourth one is where the disclosure is made by the express or implied consent of the customers. These 4 things are existed in the practice when the bankers is doing it. So, the bankers, as far as concerned, that I am telling you, even not only during the existence of the relationship with the bankers, even after the close of the account or when the customers dies, the bankers has to continue that the maintain or to you can say continue the duty not to disclose that information to the third party, even after, as I have told you, even after the closing of the customer's account, or we can say even after the customers died. Now, in India, when as far as concerned these provisions, that is the compulsions or you can say the duty which has been imposed, that has been made under section 44 subsection 1 of the State Bank of India Act 1955. Section 52 subsection 1 of the State Bank of India Subsidiary Banks Act 1959 and section 13 of the Banking Companies Acquisition and Transfer of Undertakings Act 1970, which imposes a statutory duty on the public sector banks to maintain secrecy in connections with the affairs of their constituents. I would like to mention one case laws here. It is a very important case. It says in under this in Shankarlal versus State of India, it was observed. Let me allow to read out. It says, out of the duties of banker towards the customers, among those duties may be reckoned the duty of secrecy. Such duty is a legal one arising out of the contract, not merely a moral one. Breach of it therefore gives a claim for nominal damages or substantial damages if injury has resulted from the breach of it. So, that is why, as I have told you, that if by disclosing any of the information, if any kinds of loss occurred due to the act of the banker, because he discloses that information to the third party, the banker is liable for what? To compensate the customers, and the whatever the damages occurred, the customers has a right to claim over the bankers, and the bankers has to compensate it. But as far as concerned, as I have told you, the same kind of practice is adopted as a practice in Indian also. The exemptions which are granted to the obligations to maintain secrecy by a banker when disclosures by the banker is justified. There are the 4 the circumstances which we can see, or the 4 heads we can. Very briefly, I would like to mention here. The banker will be justified in disclosing information about his customer's account on reasonable and proper occasions only, as we can see. The one is closure under the compulsion of law. There are the certain provisions of the laws where you can say the bankers is compelled to disclose it. When the law requires to disclosure of the state of a customer's account, he cannot override it. His obligations to his customers is subject to the duty to the law of the country. The banker would therefore be justified in disclosing information to meet the following statutory requirements. There are the certain acts which compels the banker and the bankers is to disclose. These are the certain few the circumstances, or you can say the sections which I like to share with you, where the bankers can have the you can say the it is mandates, or you can say these provisions mandates the bankers to disclose or to furnish the information to the third party, and the third party means here that who is authorized by a particular act. Particularly under these authorities, the some of the authorities, they are empowered to see the details of any customers when they are investigating. So, these are some of the act which is talking about. The one under the Income Tax Act 1961, the authorities under section 131, 133 and 285, they are empowered. The income tax authorities are empowered to collect any information from the banker, and the banker is bound to disclose the information to the authority, and the authority empowered, as I have told you, under the Income Tax Act under section 131, 133 and 285 of the Act. The Bankers Book Evidence Act 1891 under section 4, where the bankers is bound to give some sort of, you can say, the documents if it is required by the certain authorities, particularly when I am talking about the garnishee order. And before the garnishee order, before passing that, the bankers, the court must know that what amount is available in the hand of, you can say, the in the account of the customers. In that circumstances, without getting the information, it cannot be imposed. So, under the Reserve Bank of India Act 1934, under section 45B, under the Banking Regulations Act 1949, section 26 of the Act, where that every the deposit which is available in the hand of the bank, the last 10 years it is not disclosed, that has to be. Under the Companies Act 2013, under the Criminal Procedure Code 1973, section 94(3), the investigation before the investigating agency, that the bankers is compelled to provide all the information. Under the Foreign Exchange Management Act 1999, under section 37, before the authority under the FEMA, that information must be closed and disclosed, and as I have told you, under the garnishee order. There are the four very important things which is very important as far as the disclosure of the interest of the public. As I have told you, the insolvency in other cases, it has to be disclosed, or disclosure of the interest of the bank have their mutual understanding. If any kind of information they require, they can take from the other bank, and disclosure under the banking inquiries, and finally, what is that disclosure under the express or implied consent of the customers. Customers may ask to someone that okay, by writing that you can disclose that information. So, the second part which we have discussed, that is very important. So, let me conclude by saying that the two obligations which, or the two duties which lies towards the banker towards its customers, the one, as I have told you, that honor the check, but it does not mean that he will honor the every circumstances. There has a right which has been granted that he can dishonor, and the power which has been conferred to dishonor, that is for the security purpose, and the other, that as I have told you, that the fiduciary contractual relation between these two, and that is between the banker and customers. So, the customer's goodwill remain with the status of its banker's status. That is why it is the banker's duty that not to disclose the information to any third party, but as you have discussed, there are the certain circumstances where the banks are entitled to disclose the information, where the some laws which I have discussed with you, the certain provisions which we are talking about, that the authorities, it mandates towards the bankers that they will have to disclose by the public interest, or by the interest of the bank, or the bank's inquiry, or there are certain time when we will find which is given by the expressly implied by the customers. In those circumstances, that can be discharged. Thank you very much.